Welcome to America's Commercial Real Estate Show, your source for market intel, forecasts, and strategies. Hello, I'm Michael Bull. Thank you for being with us. This show today is brought to you by ShareFile. Look, if you send sensitive documents, you want to check this out. We use it at Bull Realty because, we have sensitive information about tenants, about businesses. Check out sharefile.com. Well, we're going to have a fun show today. We're going to do a lease negotiation show, right? We're going to have a negotiation of a lease with two attorneys live on the show. And we're invited the Atlanta Bar Real Estate Group here. So they're all out here in the lounge looking over Studio One here. So welcome my guests. So we have Chris Troutman. He's with Alston and Bird. Welcome.
Thanks for having us.
And Meghan Gordon, she's with Arnall Golden Gregory. Meghan, good to see you. Thanks for being with us.
Thanks for having me.
All right, so we're going to start off with some lease negotiations. And look, I think everyone in my mind needs to know a lot about leases. I think it's the backbone of commercial real estate values. And sometimes, depending on the clients, we see not enough attention paid to leases. They can last a very long time and control a tenant's business. They can control the property and the value. I think all of us, no matter what we do in the commercial real estate industry, should be well aware of leases and all the terms and how they impact. Now, I always recommend that on any lease negotiation that your clients or you are represented by a real estate attorney in the state you work in. I also recommend your real estate attorney work closely with a broker that specializes in the space so that you can work together and help the client through the situation. Well, Chris is going to take the landlord side, right?
That's right.
And Meghan, you're going to take the tenant side. And one of the things that occasionally comes up in lease negotiations are guarantees, right? So let's say that, Meghan, you represent the tenant, and the tenant doesn't want to have corporate guarantee. They don't want to have any guarantees personally or anything. But Chris, your landlord's like adamant. It's like, no, I can't do this. I can't spend the money on TI, on tenant improvements and leasing commissions without a guarantee. So Meghan, why is your tenant so concerned? I mean, the landlord needs to make sure the rent's paid. Why is your tenant not wanting to guarantee this lease?
Yeah, so I think if you think about it from the 10,000 foot view, a guarantee is just a credit enhancement. And for me and my client, who is the tenant, we've got great credit. You wouldn't have done this LOI with us if we didn't. And also, I'm going to come into this space. You're going to deliver it as a vanilla shell. I'm going to spend $1 million building it out. What more guarantee do you need that I'm dedicated to the space? I'm dedicated to your facility, and I'm going to do my best to be a good actor.
That's right, Michael. Obviously, as Meghan mentioned, the guarantee is going to be part of the underwriting of the deal, and it's going to depend on the type of tenant that we're negotiating with. Obviously, if you have a large creditworthy tenant, a guarantee might not be as necessary as it would be for a smaller or a newer tenant. But basically, what the landlord is looking for is an assurance that the tenant is going to fulfill the obligations. We've got different types of guarantees as well. You might have a payment guarantee, a performance guarantee. So depending on what the tenant is actually able to offer as a backstop to guarantee their obligations, we might have some flexibility to either remove the guarantee or to negotiate some burn off. But at the end of the day, the landlord's going to want to know, tenant, can you actually fulfill these obligations? And as we see in a lot of leases, one tenant or one entity might sign the LOI or come to the landlord and say, I'd like space in your building. But at the end of the day, the tenant entity signing the lease is going to be a subsidiary or an affiliate, in which case the landlord is always going to want to know which pocket has the money. And that's the pocket that I want.
Yeah, that makes sense. So Meghan, landlords came back to you and said, look, we've got to have some guarantees. What are a couple options you might throw out there to try to work through it?
Sure. So I think the options are fundamentally different. If what you're asking for is a corporate guarantee, I think the situation is also a little different. If the tenant you're working with is a franchisee and there's a franchisor and a franchise agreement, in that situation, I think it's fair to look to if the tenant has a corporate entity, that whatever that corporate entity is, provided that that entity has the requisite credit. I suspect your answer is going to be whatever credit they have is still not sufficient. I need to be able to get to a personal guarantee of the person that answers for this SPE, special purpose entity, for this tenant, whether that tenant is a franchisee or a new concept. In that situation, I look to two things. One, I want to be really sure whatever I'm agreeing to within the four corners of my guarantee isn't inadvertently circumventing what we've already negotiated in our default provisions. So you shouldn't have additional rights in a guarantee that I haven't given you in your remedies as landlord in the event that I default. The other thing that I'm looking to is whether or not we can discuss some kind of sunset on the guarantee with a 1-year rolling obligation. So for those that don't know, what that means is I'm going to ask you for a break point at such time that my non-monetary obligations terminate. So you can't come to me if my tenant's speakers are too loud. But if my tenant doesn't pay its rent or it doesn't pay its additional rent, I will agree to pay for those things for 1 year from and after the date of default.
So what I hear as a landlord is that you're not willing to actually obligate yourself for the full lease term for the full rental value, which is what I'm most interested in, right? I'm signing up for a tenant. I expect that this lease is going to bring an income stream over the term of the lease. So I'm going to be very hesitant to agree to any limitation as to whoever the backstop entity is in this guarantee for to burn off any of these obligations. But I think you do bring up a great point in that who is going to be signing this guarantee is really what I'm most interested in. A personal guarantee is great if the person who's actually signing that guarantee is the one who has the net worth standing behind the entity. At the end of the day, what we're really concerned about are the financials. So every lease negotiation is going to begin with the underwriting by the landlord based on a review of the tenant's financials. So if I see that the person has no assets, then a personal guarantee really isn't going to be worth anything to me either. So again, at the end of the day, I want to know where's the pocket, and that's what I'm going to go after.
Yeah, but I think everything that we're talking about is an allocation of risk. And when you're thinking about a guarantee, regardless of whether it's a corporate guarantee of an entity that's got tangible net worth, or if it's a personal guarantee of an individual who might be a high net worth individual, no guarantee on the planet is going to have a liquidity covenant. So my argument back to you as a tenant is always going to be, it's just another contract that if I default on, your remedy is still just to sue me.
Well, that's a great reason why I want to see your financial statements.
Well, Chris, what if Meghan comes back to you and says, look, I know you're spending $150,000 to build it out. You've got $50,000 of leasing commissions. And she comes back and says, well, what if we just guarantee $150,000? And not only that, we want to amortize that over the term. So if there's only a year left, only a fifth of that if it's a 5-year lease. What would you say to that?
Well, bringing me back to where I was at the beginning, if the deal doesn't do anything for me, right? I mean, a guarantee of what I've already spent out of pocket just brings me back to zero. So it's not going to be really very appealing to me.
Mm-hmm. And
well, I'm not going to give you a letter of credit. So that's all you're going to get.
So some other ideas are very large security deposits, right? Maybe a lot of rent up front. What about a burn off? Maybe if the tenant doesn't default in the first year?
The first year might be a little aggressive, but I think that the point that if you have a well-performing tenant who can fulfill their obligations, who can demonstrate the fact that they are not at risk of being insolvent or falling into default, I think a landlord's going to be more willing to negotiate a burn off, obviously with all of these conditions fulfilled.
And do you guys expect that a major item like this would be covered in a letter of intent? Let's say that you weren't involved in the letter of intent. Would you expect it to be there or hope it was? Or
on the landlord side, I would hope that my client has put it in the LOI.
Yeah.
But all that to say, at the end of the day, there are plenty of examples of lease negotiations where you do get into it and find out that, in fact, the tenant entity is not who you think that you're getting on the lease. And that is a perfect example of when you then need to raise the issue. Or again, it's finding out that, in fact, okay, well, this tenant that I thought had all of the credit behind it, now that I've looked at your financials, I see that you are just a subsidiary and all the money is actually at the next level up. And then is when I want to start talking about, okay, guys, this is not enough. We really do need the corporate guarantee here.
Yeah.
I think same answer on the tenant side. As a lawyer, my hopeful expectation by the time I've gotten the LOI, the deal has been underwritten, the business points are decided. A guarantee all day, every day is going to be a business point. In the event that it's not in the LOI or I get an LOI that says something to the effect of there will be a guarantee, then it's something Chris and I will have to argue about. What's the value of that guarantee, for how long, and by who?
Yeah.
And to Megan's earlier point, I mean, a guarantee is a very complicated document that does require quite a bit of negotiation. Nobody should just be signing a guarantee that's put in front of them, because they are way worse than a lease, essentially, in most cases, in terms of the obligations you're signing up for.
Yeah, well, good point. And as a broker, I always recommend that major points like that are included in a letter of intent, and so that you don't have a deal fall apart on such a major item later after we spent money and spent time. Well, let's go on to another thing that really comes up a good bit, and especially now with the economy. Let's think about office properties right now. Some of the office landlords have lower vacancy or higher vacancy and lower occupancy. And some tenants and tenant reps are concerned that will the landlord be able to perform their obligations related to tenant improvements, lease commissions, and actually just operating the building. So let's talk about self-help clauses and set-off rights, because most leases, as I see them, do not let the tenant really do any self-help. They can't do things. They can't pay a mortgage. They can't pay utilities. They can't fix a roof. They can't do these kinds of things. So if the landlord's not doing it, they have a default and they don't have a lot of remedies. Let's say, Chris, that you represent the landlord. You don't want any self-help clauses. You don't want the tenant getting involved in that. But Meghan, you're really concerned. You've got a tenant that if the roof's leaking or the parking lot's not maintained or they don't pay the tenant improvement allowance, you're really out. So, Meghan, what do you tell the landlord there about your need for a self-help clause?
Yeah, so I think self-help doesn't work in a vacuum.
Mm-hmm.
In order for a tenant to have self-help, which is the ability for them to step in and perform the obligations of the landlord has already fundamentally failed to so perform those obligations. And within the four corners of the lease, what that means is I, as a tenant, have already notified you, hey, there's this maintenance or repair obligation that under this lease is yours. We've contractually agreed to it. You're not performing it. It's now deleterious to my business, and I need to have an ability to step in and fix it myself. And I don't think that that's really controversial. Where it gets controversial is what exactly am I allowed to self-help? And if those things step into the arena of a warranty that landlord is the only holder of, and I potentially invalidate that warranty in performing my self-help, or if I'm in a multi-tenant or mixed-use center where there's declaration obligations that flow directly to the landlord, if I'm stepping outside of my premises, which is my box, there is a pretty good chance that I'm opening up liability to the landlord. And so that's where it gets very fact dependent and candidly where all the arguing happens.
Yeah, I think there's a lot of assumptions in that statement, but my general position as a starting point as a landlord is that it's my building and I'm the one who's going to take care of it. I don't want tenant touching it. I don't want you, as you mentioned, exposing me to any liability or messing anything up with the building. So that's as a starting point. But really the concept of self-help is largely dependent on the asset class and the type of tenant in there. So, I mean, in an office building where you may have 40, 50 different tenants within that building, obviously a landlord is not going to be able to give 40 separate tenants the right to go up and fix the air conditioning because it's not fixed. It's just not the way it's going to operate. In an industrial building where you might have a single tenant user and the landlord still has responsibility for the roof and the structure, say, that might be a case where you start talking about, okay, I understand as a landlord, my only obligation is to take care of this roof. And if I have in fact failed, and you can demonstrate that, and you've given me at least 2 notices, and I failed to get out there and do so, well, then you can go ahead and use my roofing contractor to go out there and fix this roof. So there's flexibility within each of the asset classes and with tenants. But from the landlord side, my main concern is, are you going to do the work correctly? Did I have a fair opportunity to do it myself? Did I get the correct notice? And are you not going to mess up my building?
So, Michael, I don't know if you heard, and I know that this is very apropos of the forum that we are in, but there's a lot of the negotiation that Chris just offered that is just bull. So I shouldn't have to give you a second prescribed notice. I've given you a notice within the confines of the notice provisions that you personally negotiated as being sufficient notice to you and your client for a failure to deliver on an obligation under a contract.
I'm trying to compromise with you here. I mean, my actual default position is you get no self-help. If I default, then you get the same remedy that any other tenant has, which is take me to court.
Or terminate. That's fine. I can agree. I can totally agree to that. If you so flagrantly fail to maintain, as you have stated, your property, and that maintenance error continues for some prescribed period of time, call it 90 days, and I close my store, those are lost profits to me. Those don't really feel like liquidated damages because it's hard to estimate what those are. And so you should just let me out of the lease. Oh, and if I have a guarantee, out of that too.
Certainly.
Hey, let's talk about an example that is an office building, let's say, because when we're tenant repping as brokers today, we go to the tenant reps will go to the investment sales side and say, hey, will you look at this building, look at their maturity, look at their loan, look at their numbers and see what's the liability for the tenant that the landlord won't pay the tenant improvement dollars. First of all, they want to make sure that that money is there. And we are seeing some landlords up front are saying, look, we'll escrow the leasing commissions, the tenant improvements. We're going to make sure you know that we're solvent landlord. Are you seeing that yet? And what about the self-help and set-off rights there?
Yeah, I mean, that is a big issue right now, and there's plenty of concern on the tenant side for the liquidity of the landlords now at this point. And as you mentioned, I think that I am seeing more office landlords be willing to consider escrowing those amounts or providing side letters or comfort letters that, the lender or the landlord themselves have the money to actually fund those tenant improvements. Again, that's going to really depend on the size and the leverage of a tenant. You're not going to see landlords offering that to 3,000 square foot tenants. We're talking multi-floor tenants where a landlord desperately wants them in their building.
Yeah, I think same answer. The soft place to land for both parties is just making sure if something does go wrong, has it been considered within the lease documents? If it does come up, is there adequate recourse or remedy? And I want to be candid, and I'm sure Chris knows too, there are certain defaults of a landlord that a tenant just simply cannot cure. And even if it has the contractual ability within its lease, if landlord isn't formed correctly, or if landlord didn't have the authority to grant me this lease, or if landlord made a covenant in this lease that my use is permitted as of right and it didn't need to go get any additional consents for my specific operation, I, as a tenant, probably can't fix that.
Great, excellent attorney to get those reps.
All day.
And what about set-off rights? Let's say that your tenant, the landlord's doing $100,000 build out. They stop. They're not funding it. Would you see typically that the tenant would have set-off rights to deduct that from the rent and cover it?
I'm actually sympathetic to that position on both sides. I fight for it all the time as a tenant attorney, but even on a landlord side, I mean, the fact is if you get to that point, it's generally because the landlord does not have the funds to actually do that repair. So I'd much rather have that offset than to have to come out of pocket to do that. But of course, we're going to fight about over the amount that they're able to offset and over how long. There's always something to be argued. Yeah,
I want to be clear. A proposition from a tenant to offset more than the actual value that you actually expended to do that repair is just that's not a workable position. Having said that, the flip side of that same coin is also to the extent my self-help extends into a quote unquote landlord obligation. So things like repair of the roof, or if there's common area restrictions and I'm obligated to use landlord's agents, their contractors, if those contractors aren't charging market rates, or if those contractors are actually related to the landlord, that's a situation where I should not have to utilize those people, because the reality is that's all money probably flowing indirectly to the landlord. So they're more than made whole.
Yeah. And one of the things we're seeing out there today is I sell office buildings, and we're seeing some lenders cut off landlords and look, we're not going to fund the tenant improvements for you. And then sometimes people think about, well, this is a really big landlord with a really big name. Well, they're going to look at each building individually. And they may have a loan that doesn't really have any liability except to turn the keys back in. So you may have a big name landlord that still would default and hand the keys back and give a tenant a problem. So I think it's something as tenants and tenant reps we should think about. Let's move on to something else. This one is something that I'm passionate about, and that is on options to renew leases, where tenants' options to renew. And sometimes I see that they're at set rents. Maybe they're escalating annually as per the lease, or there's a set rate, and then sometimes I see, it should be at a market rent. Okay. So let's say, Meghan, you represent the tenant. You'd like to know what the occupancy costs are going to be so your tenant can plan. You want us to have maybe 3% annual escalations so that you know when your tenant exercises that option, you really know what the rent is. But Chris, your landlord said, look, I don't know. The rents could be much higher, especially when we look at a market today, right? Maybe the rents are a lot lower today on an office building, and in 3-4 years, they could be much higher. In fact, that's what I think could happen in a lot of buildings and a lot of markets. So Chris, what do you say back to Meghan when you're in that situation?
Well, first I'll say that I think this is where brokers can actually really add a lot of value here by demonstrating sort of the trends in the market rent and where they think that a landlord should land, because obviously, tenant wants some assurance as to what their rent's going to be in the event they're able to even have an option to renew. A landlord, while we may derive some benefit from having the tenant be able to actually stay in that space and not have to go out to the market and find a new tenant, it's really mostly to the tenant's benefit to have this option to renew, because especially if we are at a flat rate rent, if we went out to the market and we're able to bring in a new tenant, obviously then we're able to increase the value of that asset. But at the end of the day, I think that we're going to want the assurance that we can get the top dollar, which is going to be at the market rent. Now that's of course, I'm not going to agree to any kind of floor on the fair market value. I only want that, or excuse me, I want the floor. I only want it to go up. I only want my market rent to go up.
And we're seeing a lot of that right now, where some of the retail rents have really risen very quickly. And some of these tenants have renewal rights at really below market rates, right? So that, I guess, is why you kind of like to have a market rate renewal option. But Meghan, your tenant makes them hard to plan. What do you say?
Yeah. So at the end of the day, both parties on both sides want predictability. And I think that predictability in the market is a good thing. Michael, your sentiment is my renewal rate is lower than the market rate right now. Maybe, but it wasn't lower than the market rate when we entered into this lease. And so that was a predictable factor that we already agreed upon 10, 20 years ago. It's not my fault that the market has increased. And also, if you look at every market right now, it is no longer an if you build it, they will come type of developers arena. So my argument to you is the success of your center and the marketability of it is my stability in the space. And so it should be whatever my pre-negotiated percent threshold over last year's base rent is. And if the market's gone up, it sounds like that's a cost that you underwrote for 20 years ago when we did this deal.
It sounds like a perfect argument as to why you should never accept the flat rate rent, because there's no benefit to the landlord ever in that case.
Yeah. What do you say, Chris, for the landlord if the tenant side says, well, look, you're kind of setting us all up for a huge argument problem. We might have to involve lawyers, brokers, and a lot of our time. What do you say to the tenant side if they come up with that argument?
Well, I think realistically, if we have a flat rate rent, then there's the ability for a tenant to just send in a notice of exercise and that's it. But when we really talk about, agreeing to a fair market rent or prevailing market rent, what we're saying is let's get together and figure out what's actually fair for both parties.
Agree to agree.
Yeah, no. Let's try and stay away from that. But I think in reality, this is also sort of a red herring, because in most leases, this doesn't actually happen. I know that it can be an expensive process to go through finding 3 brokers and coming up with your own valuations. But really what's going to happen is the tenant has a right on my building, and I've got a tenant that has this right. I'm going to talk to the tenant and we're going to figure something out. So these provisions very rarely ever even get exercised or go through the full process. In reality, you're going to have 2 parties with a broker involved saying, let's get to the table and figure out what's a workable solution for both parties.
I would agree. I would say, even from the tenant perspective, if I'm in a situation where I'm on the front end of a lease and I've got an LOI, and that LOI sets forth that I'm not going to have prescribed renewal, I'm going to have fair market value based renewal, the things that I'm looking at is how are we defining the market? So sitting here in Sandy Springs, I would argue that this market is not the same as a core Midtown Atlanta market. And that distinction is fair to be made within the lease now, so that it's not an argument we're having 10 years from now. The other thing that I'm looking at is who is going to decide the fair market rate. Is there adequate time on the part of the tenant to receive a notice from the landlord setting forth their estimation of that rent, which is going to include whatever evidence they're using to backstop that estimation. And enough time for me to make a decision whether or not I want to renew based on that, or if it's just in my best interest to leave the space and pursue a new one.
I think that's right. We're just looking for guardrails on each party
Yeah.
to actually get to the right result.
Yeah, I shudder when I see it's a renewal right based on a market rent at the time, and it's like 2 sentences. Like, wait a minute.
I find a lot of brokers that love
Yeah.
that.
A lot of argument. I'm going to jump to something else, and that is sublease and use clause. There's a lot of tenants today want to have flexibility because they don't know what the market's going to change, and they want, Meghan's tenant wants really liberal sublease rights, and including that, they want liberal use rights because they don't want to be restricted. Like if I was subleasing this space, if I was limited to commercial brokerage shops, that limits my subtenants. So when you get that lease back and it has all these liberal sublease rights and use rights, what do you say? How do you deal with it?
Yeah, I think a typical landlord position is to narrow that down as much as possible. But I think that there's a real risk in that as well, that is not doing your landlord client a service by if you were only limiting it to commercial brokerage. Certainly a landlord would be willing to have many uses within this office. But at the end of the day, what we're really concerned about is, again, depending on asset class, is what did I sign this tenant up for? What's my expectation? A shopping center is very different than talking about an office use. I mean, there's so many different types of office use that a landlord would be comfortable with. It's very different than talking about in a shopping center where I might say, okay, I'm allowing a fitness center, which even 20 years ago, that would have been controversial. Now I don't want somebody in there doing something completely different that's going to alienate all the other tenants surrounding it. So really, it's just focusing in on what's important to driving the value of that asset.
So you really want a lot of control is what you're saying.
Absolutely. Especially in a sublease case where if I don't have the correct provision and I've inadvertently allowed my tenant to go out to the market and bring anyone they want in, now I've lost all control. So
Meghan, what I'm hearing from the landlord is it's really up to them, not up to your tenant, and your hands are tied.
Yeah, they're not. So I want to be clear. I think the push-pull between both parties is always going to be, I as a tenant, especially if I'm a brand, like in the retail context, I need to have the ability to evolve my brand. I can't be hamstrung by having to come to landlord for consent because I want to do new menu offerings, or I have a sauna that now wants to do like fitness exercises and yoga in it. There's some level of just rationability in there that we can certainly contract around on the front end. Typically, we land on something equivalent to like the brand standard, which means however I'm operating that exact same brand across a majority of the other stores in the United States. That only works if I've got multiple units or I'm a recognizable entity. If I'm not a recognizable entity, the fear that I have is if I'm a smaller tenant, maybe I've got a big footprint, maybe I don't, and I just simply want to change my use or I want to sublease to somebody else to utilize a portion of my space, same answer, I've got to be able to have some ability to answer for my rental. If I'm in that position where I'm doing that, typically what that means is there's something that's fundamentally not working. In that situation, my concern is going to be, if I ask you for that, because I have to under the lease, are you going to recapture my space? Because I don't want to lose it. Those are the places where it really just, for me as a tenant, it depends on who my tenant is. It depends on what type of asset we're in, which Chris is very correct to point out. An office use, a standard office use, and a standard retail use have so fundamentally changed over the last 5 to 10 years that they're virtually meaningless.
Yeah. So you want to have your cake and eat it too.
Always.
I think on the retail side, especially, it's a much more complex discussion. As you mentioned, for a recognized brand, I think a landlord is probably going to be a little more comfortable recognizing that brands do transition, especially if you do have a successful brand that may, even though they're undergoing some kind of transition, is still doing well in the center. You're going to be a little bit more flexible. What we're really worried about is signing up a coffee shop and then having a marijuana shop come in, something, a totally different use that now we have no control over. Because as you know, Michael, and the retail center is like a living organism. Every piece of it that changes affects all the others. So then you start talking about co-tenancy issues and exclusives, and are you giving another tenant some right by allowing this new use in? So a landlord is just going to have a much more critical eye.
True, but I do want to be clear. There's a distinction to be made in what Chris just said, even though I don't disagree with the sentiment. If a coffee shop evolves into a quote unquote marijuana shop, its obligations are still the same within the four corners of the lease. It has to comply with law, and it has to make sure that it's not inadvertently allowing landlord to default on landlord's obligations. So it can't step on the toes of other tenants in that same building. It has to obligate itself to the prohibited and permitted uses. So if the law evolves to allow a coffee shop to serve THC in its coffee, I would say that landlord cannot step in its way.
Again, more assumptions. That's exactly right, though, because I mean, this is why a landlord and their attorney need to be so careful about crafting these, because a landlord may have covenants in its loan documents by allowing a certain use in, and now they've breached these loan covenants by allowing a THC coffee shop.
And exclusives, right?
That's right.
Yep.
Well, Meghan, Chris has come back to you. He wants really tight control on the uses. I wants really tight control on sublease. But your tenant said, look, we might be selling our business. We have multiple locations. We might do a merger or sale. He might stop our whole deal. What do you do there?
I would hate for a tenant to be in this situation, because experienced practitioners like Chris and I would have pre-negotiated change of controls and permitted transfers into this lease so that nobody is coming to the other party for consent. The same is true of landlord. If landlord has a change of hands, it doesn't want to have to come to its tenants to notify the tenants and get permission. Typically, that's a very soft place to land where it's mutual. I can understand from the landlord's perspective if I'm only selling a minority of my interest, such that there's not a change of hands at the umbrella of my entity. It just happens to be whatever SPEs have this space. That should be a prohibited transfer. I should not be able to do something indirectly that I can't do directly.
Again, this goes back to the underwriting of the deal. Is what does the landlord think it is getting from this tenant? And so a landlord is going to be very hesitant to allow these changes of control, especially where you have any kind of founder or core group that is driving the growth of this tenant. We want to make sure that these are the people who are going to remain and are going to be responsible for making sure that the tenant can fulfill its obligations. As a landlord, I'm never going to agree to any kind of prohibitions on my transfer of any of my assets. Obviously. So I think that, again, you need to be very clear about which tenant entity are you trying to sign up? And we don't want the tenant to be able to just, willy-nilly be able to transfer its rights to a new operating entity.
Well, it wouldn't be willy-nilly.
Nilly-willy?
No, it would be documented. There would be a clear exchange.
You said you didn't want to come for consent. You wanted just the right to do
I'm happy to notify you afterwards. And I'm even happy to assign this lease interest to the assignee of my corporate interests.
And you'll stay on with your guarantee, and you'll give me a new guarantee from this new entity.
Probably not. Also, I'm probably a disregarded entity at that point. So
yeah. That's awesome. Well, Chris, I appreciate it. Meghan, great negotiation here. Thank you.
Thanks for having us, Michael.
Appreciate it.
All right. And thank you for watching and listening all around the country. Hey, let us know what you think. What are your comments? Obviously, lease negotiations can get very heated at times and very important. And like I said on the onset of this show, I think we need to spend a lot of attention to leases because they can last for decades at times, really control values of properties and really control the tenant's business. And there's so many aspects of leases that we did not cover here. So make sure you have good attorneys like these two involved in your deals. And I thank you for watching. Thank you for listening. Thanks for sharing the show. Until next week, be sure that you always lead, learn, and laugh. And join us for America's Commercial Real Estate Show. America's Commercial Real Estate Show is brought to you by Bull Realty, commercial real estate sales, leasing, and advisory services. Visit bullrealty.com or reach out to me directly. My email is michael@bullrealty.com.
By ShareFile. Designed with real estate and other highly regulated industries in mind, ShareFile offers secure digital solution to simplify workflow and improve collaboration. Visit sharefile.com. By Commercial Agent Success Strategies, 21 cloud-accessed agent training videos. Learn more at commercialagentsuccess.com. You're invited to subscribe to the show wherever you listen or watch the show. You're also invited to subscribe to a weekly email announcing the show topic and guests at creshow.com. Thank you for watching, listening, and sharing America's Commercial Real Estate Show.